conference will now be recorded.
And now I'll hand it over to
Hello.
Anna.
Thank you, David. Hello, everyone. Welcome to this evening's program. My name is Anna Vanskoik. I am a reference librarian at the Hopewell branch for the Mercer County Library System. I want to thank Colorful Dreams for sponsoring tonight's program, Powers of Attorney, Guardianship, and Essential Legal Planning. Before we get started, I do want to invite all of you to locate other virtual offerings that the library has, as well as events taking place at all 9 of our branches. And the link that I'm providing to you into the chat, this gives you an opportunity to see where the chat is, so you'll know where you can put questions in. And as Dave said in the beginning, we will be addressing those questions at the end of the presentation. At this point, I'm going to go ahead and turn it over to Ed Monahan, who is a founder of Colorful Dreams Incorporated.
All right, welcome everyone and good evening. Thank you for joining us tonight and taking the time to be a part of this important conversation. Before we begin, I want to thank our host, the Mercer County Library System. We're grateful to the Mercer County Library for providing the platform for this program and for each of you for joining us here tonight. As said, my name is Ed Monahan and I'm the founder of Colorful Dreams. Colorful Dreams is a nonprofit organization based right here in Mercer County. Colorful Dreams is dedicated to assisting individuals who need assistance with the activities of daily living, commonly referred to as ADLs or IADLs, as well as their loved ones and caregivers. Through our Homes for Hope initiative, we're committed to providing safe and affordable community-based supportive housing options. And through Colorful Dreams Cares, we offer education, training, and community-based programs designed to help families, caregivers, and advocates navigate long-term planning with clarity and confidence. Our work focuses on proactive planning, informed decision-making, and compassionate support for individuals and families. Today is our inaugural session of Colorful Dreams Care speaker series, and we're extremely grateful you have joined us here tonight. Colorful Dreams began from a story not dissimilar to the story that likely brought many of you here tonight. Several years ago, my family found ourselves caring for my aunt and my grandmother. Like most families, our priority was keeping them safe and supported. But what we did not fully understand at the time was just how critically important having estate planning documents, such as powers of attorney, would become. We learned very quickly that even when families are doing everything right, things can become complicated without clear legal authority. Simple decisions can take longer, and access to information can be limited. This increases stress during moments when emotions are already high and when clarity matters most. Those experiences stayed with us and ultimately led to the creation of Colorful Dreams. Our goal for these training events is to help families avoid crisis-driven decisions through education and planning. Tonight's session, Powers of Attorney, Guardianship, and Essential Legal Planning, is designed to help families understand the legal tools available to them, recognize when those tools are sufficient, and know when additional planning may be needed. We realize that this topic raises a number of questions, and we will open the session at the end at the end of our speaker's presentation. And as said previously, you can enter them into the chat at any time. Tonight, we are honored to be joined by attorney Ryan Seclair. She is a principal with the law firm Porzio, Bromberg, and Newman. She concentrates her practice on elder law, disability law, long-term care planning, estate planning, trust administration, and government benefits planning and advocacy. She is also a certified elder law attorney. Ryan brings extensive experience working with families facing the exact questions we are discussing tonight, and she is known for explaining complex legal topics in a clear and practical way. Ryan, thank you very much for joining us this evening. I will now turn it over to you.
Thank you so much. Let me go ahead and share my screen. That way we can see the slides as I'm talking about this stuff here. And of course, if there's any issue, if anybody can't see it or anything, please let us know. But otherwise, I'm going to go ahead and start running through some of this material with you guys. So, excuse me, I have a frog in my throat. All right, so we're going to talk about power of attorney, guardianship, and other legal planning that you may need. As I said, my name is Ryan Seclair. I have offices in Parsippany, New Jersey, a little bit north of you guys, and I also have an office in Clinton, New Jersey, and I actually live in Hunterdon County, so I'm not too far away from you guys there in Mercer County. I am a certified elder law attorney. There are only about 50 certified elder law attorneys in the state of New Jersey. So this is really my bread and butter. This is what I do every single day, and I don't do anything outside of this world. So I want to take the time today to really explain to you why these documents are so important. And I think by starting we can start with our learning objectives, right? What do we want to learn about today? Well, when we have a senior, right, they're becoming physically frail, maybe mentally frail, right? They're having cognitive decline. Or maybe you have a person in your family who is just a person with disabilities. Maybe they have a developmental delay or intellectual or developmental disability, or maybe they were in an accident, right? So we kind of see it at all ages. This isn't just a concern for people who are in their 80s or their 90s, right? I am a firm believer that if a person is 18 years or older and they have the cognitive ability to execute legal documents, that they should do so, right? It's about autonomy, self-determination. What do I want? I get to make these decisions. And so by having these documents in place, you are making the decisions for yourself. You're not just allowing the court system to take over and make these decisions for you. And, we're going to see as we go along through this, some of the difficult consequences. Ed had kind of alluded to some of those things that happen if you don't have your ducks in a row and something should happen. And so there's really two time periods that we're going to focus on today because the documents are different. We're going to talk about the documents you need while you're alive, and then the documents that you need after you pass away. So we're going to start with during your lifetime. And there's really two important documents that you should consider having. One is a power of attorney. The other is an advance directive, commonly called a living will or a healthcare directive or a healthcare power of attorney. You may have heard all of these different things, but they all kind of mean the same thing. And we're going to talk about that. So we're going to start with our power of attorney. And while it's pretty straightforward, conceptually, right? The power of attorney gives an agent the authority to handle your financial affairs. So if I have a power of attorney appointing my husband as my agent, he can handle my financial affairs for me. Guess what? Just because we're married doesn't give him the right to handle my financial affairs. You got to have the legal documentation to support that. So there are two types of power of attorney. There's an immediate power of attorney, and there's a springing power of attorney. What's the difference? An immediate power of attorney, the minute I sign it, it's effective, right? I sign it, appoint my husband could take that document down to the bank and handle my banking for me. Springing springs into effect upon the occurrence of some event. So typically it's when two doctors determine that the person who signed the power of attorney is no longer able to handle his or her own legal or financial affairs. They sign certification saying, yep, this person can't handle their own affairs. Now the power of attorney springs into effect. And you might be thinking, oh, that's what I want. I want it to take effect when I can't do it myself anymore. But the problem with springing power of attorneys is when you need them, you can't use them, right? I need to now go take steps to be able to use that springing power of attorney. So I really don't like them. They're there, they have a place, but it's not my preference because when I need it, I can't use it. And sometimes the doctors don't want to sign certifications, or the banks often say, okay, you got a certification, but it's not good enough. We don't like it. We need it to say something a little different. And so you still end up in this situation where you can't use the document. So that's immediate versus springing. So the most common is a general, immediate, durable power of attorney. Most of those words have a very specific meaning. So general versus limited means that it gives the person a lot of powers, right? If it's general, it means you can go to the bank, you can sell real estate, you can open bank accounts, you can file my taxes, you can do a lot of stuff if it's general. If it's limited, it means I'm just giving you the power to do like one thing, right? I need you to sign off on the sale of my house because I'm on vacation. That would be a limited. So most power of attorneys are general. And then, like I said, we have immediate, which means it takes effect the moment it's signed. But what does durable mean? So durable means that it continues regardless of whether the person later becomes incapacitated. So I sign my power of attorney. I have good capacity. I understand what's going on. I understand what I'm signing. 2 weeks later, I have a stroke and I no longer have capacity. If my power of attorney is durable, that means it's still good. I can still use it. But if my power of attorney is not durable and I had that stroke, now my power of attorney is no longer effective. So you might be saying to yourself, well, why on earth would anybody have a power of attorney that's not durable? And I would agree with you, right? It's a bad document if it's not durable. But the law says it needs to explicitly say that. It needs to say it's durable for it to be durable. And so for a really long time, I used to say, I've never in my career seen a power of attorney that's not durable until I saw one. So you actually have to check. It might not be durable. You got to look, make sure that wording is there. We talked about what springing means. So I always like to tell people, not all powers of attorney are created equal, right? Just because you have a power of attorney doesn't necessarily make it a good power of attorney. So if you have a power of attorney that's one page and it says, I give my agent the authority to do everything for me, that's not a good power of attorney. Because in New Jersey, in order to have certain powers, they have to be explicitly listed. So a general grant of authority is not enough. You have to say, you have the power to handle my bank accounts. You have the power to sell my real estate, for example. The two powers that I see missing most frequently from power of attorneys, or that are just not done well, the power to make gifts and the power to create trusts. So as an elder law attorney, one of my biggest practice areas is asset protection from long-term care costs. If I have somebody who's going into an assisted living facility or a nursing home, I might want to make gifts of their assets in order to protect them. Now, there's a lot of complexity to that, but it might be part of a plan that I implement for somebody. But if they don't have capacity to agree to that gift and my power of attorney doesn't give me the authority to do it, guess what? I can't do it. And so you've got to have a good power of attorney so that we can engage in some of these asset protection strategies. Same thing with trusts. You know, one of the Medicaid programs, if you have income over a certain limit, you have to create a trust in order to qualify. Well, if your power of attorney doesn't give you the authority to create a trust, now we can't do that. We got to go to court. So you got to have a good power of attorney. And I know some people are like, oh, this thing is so long. It's so long for good reason, right? We need it to have all these powers. So one of the questions I get a lot is, well, who should I appoint? And that's the beauty of this. Remember, I talked about self-autonomy and making decisions for yourself. The power of attorney, you get to decide, right? Do I want my husband to be my agent? Well, maybe my husband has some cognitive decline. Maybe I don't really want my husband to be my agent because, you know, he's struggling. Maybe I have 2 kids. Do I want one, then the other? We call those single agents, right? One agent, if that person can't serve, then the next. Or do I have co-agents? I want my 2 children to serve together. Now, there are pros and cons to both approaches, but we have that choice with the power of attorney. We can do single or co-agents. But whomever we choose, they're handling our finances. Do I really want the person who's filed for bankruptcy 6 times to be handling my finances? Maybe not, right? So we really need to think about who we're appointing and the job we're asking them to do. The power of attorney is revocable, meaning you can get rid of it, right? I had a power of attorney. I don't want that person to be my agent. I can rip it up and do a new one. And I have that ability. As long as I continue to have capacity, I understand what I'm doing, I can revoke it at any point and start over. And the cost, right? Power of attorney is an inexpensive way to address who can handle your finances if you're unable to do so yourself. So the next document is the Advance Directive for Healthcare. And as I said, it's commonly called a living will, a healthcare directive, a healthcare power of attorney. Any of those names are fine. I call it an Advance Directive. So there are 2 components to an Advance Directive. There is the appointment directive or proxy. So who's going to make medical decisions for me if I cannot make them for myself? That's the appointment. And then there's an instruction directive. What kinds of medical decisions do I want? So it's two parts. And sometimes you might see two separate documents for this. And that's okay too. It's not wronged. I like to do it in one, but you sometimes see those two pieces in two different documents. With the appointment, unlike the power of attorney where we can have co-agents, with the healthcare directive, it's one, then the other, successors. And there's good reason for that under New Jersey law. And the reason for that is, well, let's say I appoint my two kids and one says, pull the plug, and one says, no, don't pull the plug. Now we're fighting, right? So we don't want to end up in court because we have two agents who can't agree on what kinds of medical decisions should be made. So there is a little known New Jersey statute that says healthcare agents must be in succession. So with the healthcare wishes, what we're really talking about are end of life decisions. If I am in a terminal, incurable, not coming back from it condition, do I want a ventilator, a feeding tube, those types of artificial hydration, right? Do I want those things? And that's going to be stated in your healthcare directive. Now, a good healthcare directive is not it's not a mandate, right? It's not telling your agent, you must pull the plug on me. It's saying, I give you the authority to withdraw those life-sustaining treatments if in consultation with my doctors, you deem it appropriate. Or you may say, I want you to do everything in your power. If it means being on a ventilator for years, that's what I want. Those are your choices, right? Self-autonomy. You get to decide what you want as far as your life-sustaining treatment is concerned. But really, the important thing is you need to have that conversation because it's such a difficult, I don't know if you've ever been in that position. It's so hard to say, what would this person have wanted? You just want so badly to do what they would have wanted. And you are taking a burden off your agent, your person that you've appointed, if you have the conversation before something happens. Because going into that room and saying, I talked to them, I know they would not want this, is such a weight off the person who's making decisions for you. So have the conversation in addition to having the document in place. Just like the power of attorney, provided you have capacity, you can change your document anytime. You can revoke it, do a new one, change your decisions, change your agents. And again, just like the power of attorney, it's an inexpensive way to make these decisions. So what happens if the person either never had capacity, right? We might have somebody who was born with an intellectual or developmental disability. They attain the age of 18 and they can't make these decisions for themselves. They can't handle their legal, medical, financial decisions. They're 18 though, they're an adult. Or you have somebody who's elderly, they're a senior and they've developed dementia and they've had cognitive decline and now they can't make decisions. They don't have the capacity to sign a power of attorney, right? Just because they can sign it doesn't mean they are allowed to it's not a legally valid document just because they can put pen to paper, right? They have to understand what they're signing in order for it to be a valid document. So if I meet with somebody and I'm like, they don't understand this, it would be improper for me to have them sign it. The right next course of action is now to go to a guardianship. So what does that look like? So guardianship is a court process, right? It is me going to a judge saying, Judge, I need you to declare that this person is incapacitated, meaning they cannot make legal, medical, or financial decisions for themselves. So it's the judge's determination, not mine. So what's the process look like? Well, it starts with 2 physicians' certifications. So I My alleged incapacitated person is examined by 2 doctors, and the doctors sign certifications saying, yep, this person is not able to handle their legal, medical, or financial decisions. Then I, the lawyer, file the court application, and then that kind of gets the process going. The court will then appoint an attorney for the alleged incapacitated person, right? We want to make sure that we are not disgorging them of their constitutional rights to self-determination without them being represented by counsel. So you've got the lawyer who files the guardianship, and now you have an attorney representing the alleged incapacitated person. And so if I represent a child, they say, I want to be my mom's guardian. We file. Now we have to notice all of the other children, for example. And so the sibling might come in and say, wait, you shouldn't be the guardian. I should be the guardian. Now they get a lawyer, and now we're fighting in court about who should be the guardian. Sometimes we're fighting about whether they have capacity, right? Sometimes it's borderline. And, they may present really well, but then, they're leaving the stove on at night, or they're, paying the Nigerian prince hundreds of thousands of dollars. So we have to, it can be borderline. And so sometimes we're fighting about capacity. Sometimes we're fighting about who should be the guardian. Sometimes we're not fighting, right? Sometimes it's just a matter of going through the motions. But it can be either way. It can be expensive because, as you can see, it can turn into a 3-ring circus of lawyers very fast. So the problem here, there are many problems with guardianship, right? It's expensive comparative to like just putting a power of attorney and healthcare directive in place. Guardianship is expensive. But it's taking away the choice of the incapacitated person. Now, if you have somebody who is always been incapacitated and they just turned 18, they didn't have a choice to begin with. But if you have somebody who's an adult and they had capacity, as long as they're doing these things while they have capacity, it's not an issue. But if they wait till it's too late, now they don't have a choice, right? We're taking away their choice. The judge is going to decide for them. We also have reporting requirements that we don't have with power of attorney. So when you're a guardian, you have to file typically an annual report of well-being. So what's going on with this person medically? Where are they living? What doctors have they been seeing? Are they still incapacitated? And you have to file an accounting. What did you do with their money? How did you spend it? What did you do with it? Where's it at? And that can be complicated depending on the size of the guardianship estate. The good thing about a guardianship, though, is it's not an all or nothing. You can have a limited guardian, or what we call is a plenary guardian is over everything. So a plenary guardian is, we have guardian of the person making medical decisions for them, and guardian of the property handling their finances. Limited, if I have somebody who's turning 18, they can do some stuff themselves, but they really need a lot of support. We might do a limited guardianship. Maybe I say, well, they can handle $1,000 at a time. They can't really have more than that because they're really easily influenced. People can take their money from them really easy. So we don't want them to have access to too much, but they can really have $1,000 at a time, and that's okay. So that might be a limited guardianship. There's all kinds of ways we can structure that. So that is what a guardianship looks like. So those are the lifetime documents. Now we have what happens when I pass away documents. So the last will and testament comes into play when you pass away. It has nothing to do with anything while you're alive, but you have to have it in place before you pass away for it to do its job. So the will states your intentions with regard to what you want to happen to your probate assets. What's a probate asset? A probate asset is something in your individual name, so not held jointly with somebody, and does not have a beneficiary on it. So I have a checking account in my name only. My husband is not on it, and I don't have a beneficiary. That checking account is a probate asset. On the other hand, my husband and I own our house together. Both of our names are on it. It says husband and wife. If I pass away, my husband automatically gets the house. It is not a probate asset. My will has nothing to do with it because he was the joint owner of our house. So we have to look at our assets in the totality. One of the things I see that is super common is, oh, I'll just add my kid on my account to help me pay the bills. Well, now we just took an asset that was a probate asset and would have passed according to your will and made it a non-probate asset because we put a joint owner on it, and it passes to the joint owner by operation of law. So if your intent is for that child to get the money, great. But if that's not really your intent, the better way to do it is to have them on the account as power of attorney, because that's not theirs then. They're just acting as a fiduciary on your account. And so we got to look at the totality. So the will names the beneficiaries of your probate assets and how you want those probate assets distributed. So we're going to get into this in a little more detail, but if I have my daughter's 7 years old. Do I want my 7-year-old getting a big inheritance if something happens to me? Not really, because she can't. She's a minor. So what would happen is if I die, leave money to a minor child, guess what? The court holds it until she's 18, and then they cut her a big check on her 18th birthday. What if I have a child with disabilities? They get an outright inheritance, and now they get disqualified from SSI or Medicaid. Don't want that either. So our will needs to explain how the money is distributed, not just who it's distributed to. We'll get into that in a little more detail shortly. The will also names your executors. So who can manage your estate when you're gone? Who can manage your money? And who's going to follow the terms of your will? You can have, like the power of attorney, you can have single executors or co-executors. And as we said, the will takes effect on death. Now, the will doesn't do anything until it's submitted to the court, right? So when you pass away, your executor takes your original will to the surrogate court, and then the surrogate court says, yep, that's a valid will, and gives them their letters of executorship. So a copy of a will is no good. You need the original with the ink and raised seal so that you can get it admitted to probate after the person passes away. Now, there are some attorneys out there who really tout that you need a revocable living trust and avoid probate. Probate in New Jersey is not problematic to me. Now, there are other states where it's really horrific, like Florida, New York, but New Jersey is not. So I am not an advocate of a revocable living trust. My experience is that most people who have them don't. You have to actually title your assets to it for it to work. And most people don't do that part. So we end up in probate anyways. So my belief is they are not generally the best document unless you own real estate in multiple states. You own real estate in New Jersey and you have a vacation house in Florida. Now you need a revocable living trust. It's not to say that trusts don't have a place, right? There are, and we're going to talk about some of those trusts in a minute, but revocable living trusts do not give you tax protection. They do not give you long-term care protection. And that's the piece that I think a lot of people miss. So if I have a person in my life who has disabilities, I don't want them getting an inheritance outright. I am also not a believer of excluding that person from my estate entirely. I see it a lot where families have 2 kids, right? They say, I've got 1 kid who doesn't have disabilities and 1 kid who does. I'm going to leave everything to my child that does not have disabilities. And they're going to just take care of their sibling. And I'm sure that child has all the right intentions. But what happens if they die, right? That money that went to this child who was supposed to take care of their sibling is part of their estate. Where does their estate go? I don't know. Could go to a spouse. Maybe that person's not going to do the right thing. Maybe it goes to the surrogate court for their minor children. I don't know, right? So you're taking away a lot of control by doing it that way. I do not think it is in the best interest of the person with disabilities to do that. What's better is to direct their inheritance to a supplemental benefits trust. So instead of saying in my will, my child gets one half of my estate outright, I would say my child gets one half of my estate to be held in a supplemental benefits trust. And here's the terms. That trust is not a countable resource for government benefits purposes. It is not set up by the person with disabilities. It is not funded by the person with disabilities. We, the testator, the person creating the estate, bypassed them. I put it in a trust that they have no control over. So it doesn't impact their benefits. Flip it around. If I gave them their money outright, what do they do if they want to keep their benefits? They can still typically keep their benefits, but they have to set up a trust. If they receive the money and they set up a trust, that trust has a payback provision, which means that on their death, the money has to go back to the state to repay them for the Medicaid benefits received during their lifetime. The supplemental benefits trust, because the money never came into the hands of the person with disabilities, doesn't have a payback. So me, the testator, I get to decide where any money that's left goes when the beneficiary passes away. So in my will, I direct money to a trust for the benefit of my disabled child. And then I say, on the death of my disabled child, if there's money left, that money goes to the other kid, if they're living, or their kids, my grandkids. I get to make those decisions because there's no payback provision. There's no age limit, right? If I'm 95 years old when I pass away and my disabled child is 75 years old, guess what? The money can still go into a supplemental benefits trust. One of the big keys here, though, and this is the problem I see often. People do the estate plan, but then fail to designate the trust on beneficiary designated accounts. So example, I have a life insurance policy. I name my disabled child as the beneficiary of the life insurance policy. It's a non-probate asset because I named the beneficiary. It never passes through my will, never passes to the trust. So you have to name the trust as the beneficiary on life insurance policies, retirement accounts. You cannot name the person with disabilities. You have to name their trust. There are multiple ways we can do this trust. I can do it as part of the will, or I can do it as like a standalone document that the will points to. The benefit of doing it as like a standalone is like, say I have multiple relatives who all want to leave this person money. I have one trust and everybody's documents point to it. So I can have one. Whereas if everybody wants to leave the money and everybody has a trust set up in their wills, now I have 15 trusts we have to manage when they all pass away. So having one trust that everybody directs to can be a really helpful planning tool. It's not as stringent, right? If the person receives the money outright and they have to set up a trust, Medicaid is all over that because there's a payback. They're watching how you're spending that money because they know the more you spend, the less they get on the back end. This is not that. Because there's no payback provision, Medicaid isn't like requiring you to notify them of transactions. They're not as stringent on it as far as accountings go. So I mean, my preference is to create your estate plan directing money to a trust for the benefit of the person with disabilities rather than bypassing them altogether, so we don't have to worry about what happens to the person. Another example, I give all the money to my well child, they get divorced. If they commingled that money at all with their spouse, now we got divorce issues. It's a mess. So it is not my preferred way to do it. So what happens if you don't get around to it? Now we have what's called intestacy. So you did not create a will and now you pass away. Where does your stuff go? Well, your non-probate assets, your life insurances with designated beneficiaries, your retirement accounts with designated beneficiaries, they go to the people you designated. It's the probate assets that we're concerned about, right? the checking account in my individual name, my car in my individual name. If I'm a single person, maybe my house in my individual name, right? So that's the probate assets. If I don't have a will, we go through intestacy. And intestacy, who gets your stuff? It's not the state. A lot of people are like, oh, the state's going to get your stuff. That's actually not true. It's the state has a hierarchy, a list of who would get your stuff first. And so if you're married, you might think, oh, it goes to my spouse. Well, that's sometimes true. If you're married and you have children and all the children are children of the marriage, then yes, your spouse gets everything under the laws of intestacy. But if one of you have a child from a prior relationship, that's your spouse does not get everything now. Now, under the laws of intestacy, a portion goes to your spouse and a portion goes to your kids. Let's say you're married and you don't have kids at all, but you have a living parent. Now your spouse gets a portion and your parents get a portion. So it can have some really wacky unintended consequences if you don't know what those intestate succession laws are. So having your will, again, it's all about self-autonomy. I get to decide where my stuff goes. You know, my parents got divorced when I was little. I don't have a great relationship with my father. If I passed away when I was a single person before I got married and had a kid, if I passed away, my mom would have gotten half, my dad would have gotten. I didn't want that. I wanted my mom to get everything. So I get to decide that, though. That's me, my choice, my life, my money. I get to decide, but I have to have a will to make it happen. The other problems with intestacy, of which there are many, is the bond. The bond is an insurance policy. So if I have a will, I say in the will, I waive the bond because I'm not going to make my executor post a bond because I trust them. That's why I'm appointing them. A bond is an insurance policy that says the administrator is going to do their job. And if they don't do their job, there's insurance to protect the beneficiaries. That's what a bond is. And so when you have an administration where you don't have a will, the administrator, equivalent to an executor, but when you don't have a will, it's called an administrator, has to post a bond. And the bond is based on the value of the estate. So if I have a really tiny estate, the bond's not going to be that big. But if I have a big estate, it's a big premium because it's insurance, you're paying a premium. So it's an annual premium you have to pay every year until the estate is finalized. So we have a bond problem. Now, the other problem with the bond is what if your executor has bad credit? They can't get bonded. So you might have a child who you trust and would absolutely do all the right things, but they have bad credit for whatever reason. They may not get bonded and they can't serve. The other thing is, well, who's going to be the administrator? You didn't appoint somebody, you didn't decide. So a judge gets to decide. Now, there's an order of priority in the legislation, in the statute. If I have 4 kids, they have equal priority. Which one of them is going to be the administrator? Well, if they can agree amongst themselves and sign what are called renunciations, then the one that they all agree on gets appointed. But what if they can't agree? What if you have a sibling who's just a jerk and doesn't want to sign anything? I'm not signing nothing. And you can't get them to sign the renunciation. Now you got to go to court. You got to file a verified complaint, order to show cause. It's a lawsuit, just like in a guardianship, where you ask the judge to appoint somebody. And the judge may say, well, if you guys can't agree on it, I'm not appointing any of you. I'm going to appoint a lawyer, me, to be an administrator of your relative's estate. So, and guess what? I'm not doing it for free. You might do it for free because it's your relative, but if I get appointed by a court, I'm not doing it for free. So now, you could have saved so much money. You wouldn't have had to pay a bond. You may not have had to pay attorneys if you just had your will in place. And the other issue, which we've talked about, is you have a relative who has a disability. We don't want them getting an outright inheritance. And that's what happens if you pass through intestacy. There's no protections on beneficiaries with disabilities. There's no protections for minor children because we died without a will. We didn't put that stuff in place. So I know that we're going to have questions, and I wanted to give a lot of time to that. So I'm going to, this is my contact information. I just put it up here when I can share it again later. I am going to, did I just close out of this presentation? No, I didn't. Okay, good. I closed out a screen and it scared me. I'm going to stop sharing. Did I stop sharing? Yes, I did. Thank you for shaking your heads. Yes. I'm not super familiar with this platform. So I hope that you guys have some questions. I hope you learned at least one. My barometer for attending a presentation is, did I learn one thing? So I hope you guys learned at least one thing. And so with that, Anna, I know you're going to ask me some questions, I hope.
Yes, some questions have definitely come through. One of the one of the first ones that came up is if people are going to, is if there's any type of handout or a copy of the slides that people would be able to have after the program.
So I'm certainly happy to circulate my slides to the folks putting this all together. I don't know if you guys are able to send those out to attendees, but I am certainly happy to send those off.
If you are willing, yeah, and if it's okay with the Colorful Dreams host, I know that people would like to have it just so that they would have something to refer back to as well.
Absolutely. I'll circulate those as soon as we get off this call tonight.
And then I had someone ask, can a living will cover any future incapacity, such as dementia?
So the living will is meant to address, again, two situations. Who can make medical decisions if I can't make them for myself, and end of life decisions. You could include a lot more detail about, I had a client recently who is starting to experience cognitive decline. He knows it, and he is very adamant that he wants absolutely no medical treatment once he starts to have, he is just adamant. And so we kind of specialized his document to those really, really unique wishes he has. But the healthcare directive is valid if you lose capacity, right? If you have capacity when you execute it and you later develop dementia, your healthcare directive is still valid, and your agent that you appointed is the one that's going to help make medical decisions for you.
That's one of my big takeaways from today is that you are giving the authority. So when I do my advanced health directive, is what I'm giving the person authority to do, which I think is because I always looked at it the other way. Well, what would my mom want? Which that conversation has happened, but she's kind of putting that trust in us. Like, I am giving you the authority to make that decision.
Right. It's a, hey, I can talk to you about what we think could happen, but it's impossible to predict every single situation, right? So they're giving a lot of trust to the person they're appointing. And that's a big takeaway, I think, too, is you have to appoint that. It's not just like, well, I'm going to appoint my oldest child because they're my oldest child. Appoint the person in your life that's going to do what you would want if they were in your shoes.
And then I have another question here. If someone has a savings account with, let's say, their niece being the payable upon death, does she need anything else for the bank, like a power of attorney or anything?
Okay, so that's a loaded question and a half, believe it or not. So all of a sudden I was like, niece, payable on death, all the things started running in my mind. So the first issue that popped up for me was, number one, it's a payable on death. So has nothing to do with while you're alive. So if somebody needs to pay a bill for you, they're not going to be able to access that account because a POD only comes into effect when you die. That's the first issue I saw. The second issue I saw is, you said niece. I didn't talk about it, but New Jersey has an inheritance tax. So when you leave money to someone other than a parent, spouse, child, grandchild, someone outside of your direct bloodline, there is an inheritance tax in the state of New Jersey. So she won't be able to collect that money, all of it. She could get part of it until she pays the inheritance tax on the money that she would be inheriting. So the question was, is she going to have to do anything? Yes. She has to file an inheritance tax return and pay a tax before she can get access to all that money.
Thank you. Ooh, I like the loaded one. A little exciting. Can you explain the difference between a will and trust, like the pros and cons?
So there's the will controls your assets at your death, period, full stop. There are lots of different types of trusts. There's revocable trusts, that is basically just a will substitute. It avoids probate as long as your assets are actually titled to it. That's the piece that everybody misses, right? So a will and a revocable living trust are very similar in what they're intending to accomplish. Who gets your stuff when you're gone? But then there are irrevocable trusts that do different things. And so those can be structured in endless kinds of ways. I have irrevocable trusts for tax purposes, right? Sometimes I'm trying to avoid inheritance taxes, or I'm trying to avoid estate taxes, or I want to make sure I have this giant life insurance policy and I don't want that part of my taxable estate. So there are irrevocable trusts that are for tax planning purposes, but then there are irrevocable trusts that are for asset protection from long-term care purposes, right? Maybe I want to set up an irrevocable trust, title my house to it so that I can start my 5-year look back and protect my house from cost of care, so that if I need a nursing home one day, I'm not selling my house and using those proceeds on that. That's an irrevocable trust function. So it depends on what you're trying to accomplish. But the will and revocable trust, I am a big believer in a will. I think most people end up having to probate anyways, even when they have a revocable trust. And that's the big benefit of a revocable trust, is avoiding probate.
Thank you. Uh, a- and can a power of attorney cover medical decisions?
So those are typically handled by two separate documents, right? You have your power of attorney for finances, and then you have your healthcare directive for medical. It's not good practice to have these documents commingled into one. So the answer to your question is probably not, but you might have a power of attorney that's like a mishmash of the two, and it's just not a good idea.
I know that we have mine. I have two separate, like it is two separate documents. Yeah.
And it really should be, but I'd be lying to you if I hadn't seen them mishmashed into
Right.
one.
And I think I know the answer to this. A power of attorney needs to be notarized. Is that correct?
Yes. So let's talk about that. So the power of attorney, in order to be valid in the state of New Jersey, every state's a little different, it only needs to be notarized technically. Now, it's good practice to have two witnesses and a notary, just like you would on a will, but it's not an absolute requirement. It just needs to be notarized. A healthcare directive, on the other hand, either needs two witnesses or a notary, not both. So it doesn't need to be notarized. You could do it with just two witnesses.
Interesting. Okay. Are conservators used in New Jersey? If so, what is the difference between a conservator and a guardian?
Okay, so you might hear the word conservator and guardian used interchangeably in like the news, right? Because California, for example, calls a guardianship a conservatorship, but it's the same thing. We in New Jersey have, it's different. A conservatorship and a guardianship are not the same thing in New Jersey. So you have to be careful about when you hear the word conservatorship, they might be talking about a guardianship if it's another state. But here, a conservatorship is essentially a voluntary guardianship where the person does not lack capacity. They agree to have someone else manage their finances. But in my, how many years am I practicing? My 15 years of practice, I have never used a conservatorship because that's what we have power of attorney for. So it has a place, but it's an extremely limited place.
And I have another thing going back to the notaries. If a power attorney hasn't been notarized, Can it still be notarized? I mean, what do you do with that then? If you have your power of
Do
attorney,
a
but
new one.
it's never been what did you say? Throw it away?
Do a new one because
Oh,
it's
do
no
no.
good. You can't just slap a notary stamp on it after the fact. You
Okay,
have to re-execute it. So you have a new blank version. They have to have capacity to
got it.
re-sign it and notarize.
Got it.
If
Thank
you
you.
had it signed but it wasn't notarized and they no longer have capacity, guardianship.
Thank you. I thought you could just slap it on there, be like, okay, here it is. Nope.
And you want to hear a funny story? I had somebody sign a deed that way, right? They signed a deed and then they slapped a notary stamp on it after the fact, and it was an invalid document. It
Oh,
got voided
geez.
because the notary is saying, I saw them
I
sign
saw them
at
do
this
this.
time.
Right. Okay, let's see. Does the benefits trust need to be specific regarding the type of payments that can be made, that it can
So
make?
great question. So the supplemental benefits, any trust for that matter, will give the trustee, who that's the person who can manage the assets in the trust, guidance, right? It says you can distribute income this way, you can distribute principal or the assets in the trust this way. And so, yes, all trusts should have that guidance in them. But a supplemental benefits trust in particular is basically going to say, look, you can make distributions in a way that doesn't jeopardize their government benefits.
Thank you. And then someone says working with someone who's disabled. If someone's younger than 65 years old becomes disabled and has to apply for SSD, do you assist with that process?
Great question. So one thing I do is assist people to make sure that they financially qualify for Social Security benefits. What I don't do is actually file Social Security disability applications. And the reason for that is there are attorneys that do only that, right? They literally only file Social Security disability applications. They have a volume practice and they have systems and processes that make it extremely efficient that I just don't have. And so it's not, it is more effective for you to go to one of them for the actual disability filing.
The next question, can a power of attorney be challenged? For
Yes.
example, by a
Oh, yes.
sibling. I was going to say, I mean, that's like
Oh,
soap
yeah.
opera.
Oh,
Yeah.
yeah. Oh, yeah. So if I have somebody, somebody signs a power of attorney and I have a kid come to me and they say they appointed my brother who stole everything from them. She was declared to have dementia 3 years ago. Well, I don't know how she signed this document. You think I'm not going to file a court application to avoid that document? Absolutely, we are. So, yes, they can be challenged. Lack of capacity is one of the biggest reasons, right? They did not understand what they were signing when a document was stuck in front of them.
Someone asked, is a guardianship a better option over a power of attorney if the person does not have significant financial assets?
No, no, because a guardianship is expensive and it doesn't give you it does give you extra power in the sense that I'll give you an example of where guardianship is really helpful versus like a power of attorney and healthcare directive. I have somebody who has dementia. We need to place them in an assisted living facility for their own safety, right? They're a flight risk. They're running out in traffic when nobody's home. Like, they need a secure place to live. I take them there. They say, I'm not staying here. I'm leaving. What controls? The power of attorney or this person who's saying, I'm not staying here? If I'm a guardian, they have been declared to not have capacity to make that decision for themselves. So that is a situation that comes up sometimes where we really don't have a choice, even though we did all the right things. But under all other circumstances, power of attorney and healthcare directive. I can handle the small amount of finances. I can handle the medical decisions. I don't need a guardianship.
Thank you. It's very helpful. And then back to the notarized power of attorneys. Which takes precedence? A notarized power of attorney that is not recorded, or a power of attorney that is notarized and recorded within the county?
Well, I feel like that's a trick question
Yeah.
because they should be the same document, right? It just like you have the power of attorney and you recorded that power of attorney, they should be the same. But if what I'm hearing is there's two different power of attorneys and one's recorded and one not, the question is which one's dated sooner, right? If the one is dated more recently and it revokes the older one's not valid anymore, whether it was recorded or not. So that's really the question, is which one's newer? And does it actually revoke the other one? I've seen power of attorneys that don't revoke prior power of attorneys. That's interesting. Now, which one's valid, right? I have two power of attorneys. The newest one did not revoke the older one. Now what? I would go to a judge and ask for advice and direction, is what I would do.
Yeah, that's
Oh,
a
it
little
is.
tricky.
This is fun stuff. I like these questions. These are good questions.
The next one is about, and this, I would appreciate this as well. Kind of reviewing this again with they said POD, but I think they mean power of attorney, POA.
What's the question?
I'm a bit confused. My two kids are listed as POA, and only one of the two kids has, no, my two kids are listed as POD, and only one of the two kids has POA. So what is the disadvantage of the POD?
Yeah, I don't understand that question. Whoever put that question in, if you could maybe clarify what you
So
mean, because if you're
yeah,
saying you have both kids on as POD, but only one of them is POD, that something's not computing there, right? If they're both as POD, payable on death, I have a son and a daughter is payable on death, they're payable on death.
but only one of the kids is listed as power of attorney.
But one is okay. So I have a power of attorney that lists both my children, but only one of them is actually on the account as power of attorney. Then I would have to look at your power of attorney, right? Did your power of attorney list them in succession and you just didn't realize that, right? That it was like one, then the other? Or did it list them as both and the bank made a mistake, not adding them both as on the account?
I'm going to let Kathy clarify that one, and we'll come back to it. Then the next one is our attorney added a page and urged us to get it notarized when we need to use the POA. Is that going to be a problem? So they added a page afterwards, it sounds like.
So some places, it's not a requirement in New Jersey, but it is in like New York and I think Pennsylvania for that matter. The power of attorney agent has to sign a page saying they agree to act, which doesn't have to happen until they need to act. So you would have the power of attorney that I sign saying these are going to be my agents before a notary. Then there would be another page that my husband would need to sign before a notary when he needs to act. It wouldn't need to have been signed at the same time I signed mine. That is something that is common in some states. That is not something we do here in New Jersey. We don't require our agent to sign a notarized page agreeing to act.
All right, so we're going to go back to Kathy's question. So hers is they're payable upon death on her savings accounts, like on her accounts. Her two kids are both listed as payable on death, and only one of the two kids is her power of attorney. So what is the disadvantage for the payable on death, or is there a disadvantage to that?
If the one kid is power of attorney and you need access to that savings account during your lifetime, the power of attorney child could take that money and spend it on you. When you die, whatever's left in that account is split between the two people you listed as POD. That's
Thank
just
you.
how it would work in that scenario.
So there's no disadvantage per se. It's just that one has the power.
Correct. One has the power
Okay.
to access it for your benefit during your lifetime, right? Because a power of attorney doesn't give them the authority to steal from you,
Right.
to be clear, right? It gives
Right.
them the authority to use your money for your benefit. But the POD says who gets it when you die. Now, I don't always love PODs because let's say I have funeral expenses and I have one really good kid who's like, yeah, we need to use this money for mom's funeral. And then I have another one. It's my brother. My brother would do this. I'm buying a Ferrari. You can deal with mom's funeral. Well, it's POD. It's their money. They can do whatever they want with it. Whereas if it did not have a POD and it passed according to your will, your executor would take control of the money, spend it on your funeral, and then distribute the balance.
Once you you might be, I think I'm babbling now, all this legal talk. Once you have a guardianship in place, is it easier to apply for Medicaid?
So it depends on the situation. So it's not having a guardianship in and of itself doesn't make Medicaid any different. It's whether you can access the documents you need to get Medicaid eligibility. So, for example, if I have a person who has a checking account in their name and they need to apply for long-term care Medicaid, it's called Managed Long-Term Services and Supports, MLTSS. I need to apply for MLTSS for my mom who has a checking account. She didn't do a power of attorney. Guess what? I can't get her 5 years of account statements because I'm not her power of attorney and she can't do it for herself. So yeah, I would need to get a guardianship to get the statements to apply for Medicaid. So in that scenario, yes, having a guardian would make it easier. But if my mom had just had the power of attorney, I could get to the same place without the guardianship.
Okay, thank you. I do have some people asking about services. I'm going to let them email you. You said you're going to put your email back up
Yeah,
for people, so I will let them reach out to you directly. But I
while we
did not want to
continue.
ignore those who had put those
I'll
questions
do
about
that while we
services.
continue to talk here. I realized that I turned the slideshow off. Hold on one second. Let me restart that from current slide, and then I will share that again with you guys. Share. Okay. Other
So there,
question.
thank you for putting that up. I
Yeah, of course.
appreciate that. I have someone on here who says they don't have the living will, power of attorney, or a trust. What do you recommend to start with when they have a single child?
So almost all the attorneys I know that practice in this area, it's like a package, right? If you come to me and you're like, I just need a will, I'm gonna be like, you really don't just need a will. You really need all of your documents, right? And sometimes I have clients who come to me and they'll bring me their old documents and I'll say, yeah, your will is good, but you really do need a new power of attorney and healthcare directive. So I would be concerned if I consulted with someone and we didn't discuss all three documents. Even if we don't ultimately draft all three documents, it should be part of the discussion. Not all estate planning attorneys deal in Medicaid. They just don't. So if you're concerned about that and you're talking about, do I need a trust for that? You should be making sure that the attorney you're consulting with specializes in Medicaid.
Thank you. And someone asked, can you name two people or two children as power of attorney?
Yes, you can name two children as co-agents. And then you get to decide, do I want them to have the authority to act independently? So either one of my kids can go do something, or do I want them to act unanimously, meaning they both have to do things together? You get to make that decision. In power of attorney land, I really like the authority to act independently because, again, if I need to do something quick, having the requirement of two agents to sign off on everything can make it challenging.
And then the person who had asked a question about guardianship is whether it's a better option over a power of attorney if the person doesn't have significant financial assets. Do you mind repeating it one more time, which probably would be a benefit for everybody anyway?
Of course. So there's no real benefit to having a guardianship over a power of attorney and healthcare directive, even if somebody has. I mean, look at it from both perspectives. If they have basically no money or they have millions of dollars, we prefer to have a power of attorney and a healthcare directive, not a guardianship, because the guardianship is more expensive. higher level court involvement, reporting requirements, all these extra things that cost money and are expensive. If they don't have much, if we have the power of attorney and healthcare directive, we never end up in expensive guardianship land. With any little things that come up that we need to address, we can do with those two documents 90% of the time.
Thank you for repeating that. I appreciate that. And then can you give a general ballpark, an average on what it would cost to draft a durable power of attorney?
So I can't obviously speak for all lawyers.
Right.
I think what do they call that when you guys when the places consult with each other and like price fix things? There's a name for the monopoly or I can't
Sketchy?
remember.
Sketchy?
Yeah. So we technically we don't really talk to each other about this stuff. So I
Right.
can tell you what I charge. And I again, most of the time when somebody needs a power of attorney, they also need a healthcare directive. So
Right.
I usually do them in a package. I charge $750 to draft
Okay.
them.
That helps.
If
That
that's
gives a
all
number.
you
That's a
need.
number. Yeah.
If that's all you need. Now it goes up from there, right? We need a will, we need a supplemental benefits trust, we need a revocable trust, we need deeds. It can go up from there, but that's the price for those documents that I charge.
Thank you so much. I appreciate just giving a ballpark. That's
Of
very
course.
nice. I have no more questions that have come in. I'm going to give it a
Okay.
second though, in case
That's pretty good. We're
someone's
like
letting it
right on
marinate.
time.
I know. Well, there were some great questions, and
They were
I
very
found
good.
it very helpful. I mean, these are all documents that I've had in place. I mean, I have them with my mother, my family, my siblings, and everything. So, but it's just so good to hear it. And I'm taking away something new, which is what you asked, right? What is one thing you're taking away? So I feel like it's been a success. Thank you.
Excellent. And I will
Um,
circulate these slides to
thank
you
you.
guys as soon as we get off this call. I'll send them out.
And we will process them then, and we will get them out to our participants. I know that there's also a feedback form that's going to come back from Colorful Dreams to kind of talk about tonight's program, and I will submit that in a follow-up email as well. Before I let everybody go, I need to thank Dave Trout, who was behind the scenes, making sure everything was running smoothly. Thank you so much, Dave. And of course, I have to thank Colorful Dreams for bringing the program to us. And Ryan, you have been just a gem. Thank you so much for all the information.
Anytime.
No, thank you very much. Thank you.
And that, everyone, concludes our program for the evening. Thank you so much for coming this evening, and we will see you in the future. Bye now.